All right, welcome to the Chapter 9 video lecture. Chapter 9 deals with conducting constitutional searches. So we've talked about kind of an overview of the Fourth Amendment, conducting constitutional seizures, and then this chapter is about the search side of that. So searches and seizures can overlap a lot. So everything that we're going to talk about this week is very on the case-by-case basis and individual analysis. Under the Fourth Amendment, what we need to have happen for there to be a search to trigger the Fourth Amendment is that there's a governmental action. All the Fourth Amendment stems from a government action. The person needs to have a reasonable expectation of privacy. So this comes from a case called Katz versus United States. And in this expectation of privacy, the person has to have demonstrated actual privacy. And we as a society need to agree that this exercise of this domain of privacy is reasonable. So for instance, when someone closes the curtains to their house, they are keeping people out. And we as a society agree that that's reasonable. If they leave their curtains open and they stand in the window and commit a criminal action, they cannot say that they took steps to keep that action private. Okay, so that's kind of the distinction that the Fourth Amendment is making. So all searches must be limited in scope, and general searches are unconstitutional and never ever legal. So there's two different ways that searches can happen. Searches can happen with a warrant or without a warrant. So first, let's talk about warrant searches. Warrant searches must be based on probable cause, supported by oath and affirmation, particularly describing the place to be searched and the person or things to be seized. So this is directly from the text of the Fourth Amendment, right on its face. So an officer has to do those things to get a warrant. They need to be able to give specific information, describe things well, and once they have that warrant, they need to execute it in a timely manner. They cannot use excessive force during the execution of it, and they only have a limited authority to detain occupants of the premises. So with a warrant, officers can only search the areas where they reasonably believe that the specified items or person could be found. Warrants do not mean that they can go into the basement if that's not reasonable. It doesn't mean that they can open every single cabinet. If the warrant is for a specific item, once that item is found, the search has to end. But there is qualified immunity for police officers when they're engaging in a search, which means that they don't have liability for actions performed during the course of their job unless they violate a clearly established constitutional right. So this makes it hard for someone to challenge a search with a warrant. Now, those warrantless searches, we're first going to start with the premise that the Constitution specifically mandates that warrants are preferred. But the times where it's reasonable to search without a warrant are if the individual gives consent, frisks for officer safety, plain feel and plain view, searches incident to an arrest, the automobile exception, exigent circumstances, open fields, and abandoned property in public places. So those are all situations where it's reasonable to search without a warrant. Looking first at consent, as long as the individual gives voluntary consent, the officers can search. They can rely on that. The evidence that they find would be admissible. The individual can revoke their consent during the search, and consent to search an individual needs to be given by that individual. So like a spouse can't give consent for the officers to search their spouse. It has to be from the specific person. There are times where an individual cannot consent to a search. So this is the landlord cannot consent to a search of the tenant. A hotel employee cannot give consent to search a hotel guest room. And those are because we as a society expect that when you are the tenant that you have privacy there. Now, frisks. Officers can frisk for their own safety. They don't need a warrant to do it, but a frisk is limited to the pat down of the detainee's outer clothing. Reasons why officers might frisk are that the suspect is fleeing, there's a bulge, their hands are concealed, or it's a high crime area. In Minnesota v. Dickerson, 1993, the officer conducted a frisk, but they felt a small lump in the jacket pocket. Officer thought that might have been crack cocaine, manipulated the object with his fingers, and then reached in and retrieved a small bag of cocaine. And the question is, was that seizure lawful? And the Supreme Court said yes, as long as as long as the contraband is instantly recognizable by plain feel or plain touch. They can seize that. So manipulation of it is not acceptable, but if it's instantly recognizable, then the officer can seize it. Now, the next concept is plain view doctrine. So unconcealed evidence that officers can see is not protected by the Fourth Amendment. So you invite somebody in. You invite the police officer in and they see drugs and scales sitting on your table. You're just out of luck. The officer does need to lawfully be at the vantage point where they are able to see, but as long as they can do so, that is well within the Fourth Amendment, and you cannot keep the evidence out. Once someone has been arrested, this officer can search them incident to the arrest. This is because of officer safety and the need to recover evidence and contraband. This comes from a couple cases in the 60s. The officers can arrest the area within the person's wingspan. So they cannot search like the entire house or anything like that, but if you could reach out and open a closet or a desk drawer, the officers are going to be able to look in there for their own safety. Now, automobile exception. Government agents, if they have probable cause to believe that the vehicle contains contraband or evidence of a crime, then they don't need a warrant because cars can move, and in the time it would take to get the warrant, the evidence in the car could be long gone. It could even cross out of the jurisdiction for the government agent. Now, the next time where a search can be conducted without a warrant is for exigent circumstances. These require immediate action from law enforcement before evidence is destroyed. And so exigent circumstances include danger to the officer themselves or others, danger of or destruction of evidence, driving while intoxicated, in hot pursuit, or an individual requires a rescue. So all of these kind of add up to all the multitude of ways where officers don't need a warrant to search, but there are parameters. The officers still need probable cause for everything but the frisk, and these are not unlimited searches. Now the next slide deals with border searches. Border searches are reasonable, especially when you're right by the border. The further away you get, more traditional Fourth Amendment rules apply. you can be searched entering or exiting the country. Special needs searches are times where the Fourth Amendment right of the individual is diminished because of some other expectation, like the individual has less privacy because they are in prison, because they are on probation or parole, because their occupation requires drug testing, because certain businesses are extremely regulated, community caretaking, or public schools, so students in public schools. All of those situations involve reduced expectation of privacy, and therefore government has can search more as long as it's limited. Now, electronic surveillance. Participating in electronic surveillance is a search under the Fourth Amendment, so the government agent doesn't have to physically be in the space to conduct that search. In all of these types of situations above, electronic eavesdropping, going through luggage, obtaining some person's bodily fluids, people have reasonable expectations of privacy in all of those situations. So a warrant is generally going to be required before the electronic surveillance begins. And this goes to the Crime Control and Safe Streets Act of 1965. This requires one-party consent to conversations, and that to obtain these types of warrants, we need to have probable cause that there are communications going on that warrant the search, and that other investigative procedures have already been tried. So that's kind of the requirement to conduct electronic surveillance. So as you work through the material, if you have any questions or thoughts, please feel free to reach out. I look forward to working with you this week.